Hi, Michelle.
Howdy, how you doing?
I'm good. How are you?
I'm okay.
Fair warning, we are recording already.
Thank you for the warning.
I have to tell myself too. Sit up straight, Shelley.
You're on your best behavior, Michelle. Don't say anything you don't want to record.
Exactly.
What was that gasp? Wow.
I was wondering if I'm on the right meeting.
You are.
I am?
You are.
Yay!
I don't know if you really meant to be in this meeting, but you're supposed to be in this meeting.
Yeah. Well, I wanted to make sure it wasn't the long-term planning.
No, this is the ICH technical assistance meeting.
That's the one I want to be on.
Yay. Then you are in the right place.
Yay!
So many meetings.
I have one that is right after this, and I'm off at 2, and I don't get to be off. So
Wow.
Yeah.
So how do we audit them?
Kimberly, I want to say thank you for being on camera. Alexis, thank you for being on camera.
Very welcome.
I love seeing your beautiful faces on camera. It makes me feel like I'm in the room with people, not isolated in my own office.
And the nice part is the more cameras that are on, the smaller our faces get. And so you don't
That
feel
is
like
true.
everyone can tell the last time you flossed your teeth.
Yep. I love it when people turn their cameras on. It makes me feel like I'm actually interacting with people rather than bubbles.
I can remember initially, when COVID hit, we all rolled out our cameras, and like seeing yourself on camera was so uncomfortable at first. And now it's like, everybody turn your cameras on. We want to see faces so we feel like we're in the room together. Just
Yep.
feels like it enhances the collaboration.
Yep. I still remember the very first time I did a meeting via video. It was actually a job interview, and I bombed it so bad because I was just so nervous, and having that little picture in the corner was just really distracting and nerve-wracking, and it was horrible.
Yep. I can definitely remember those moments where it's like, is that what I look like to everybody else?
Oh, man. And now it's just like, yeah, okay, it's just another day.
Yeah. Oh, my camera's on. Like, you don't even realize it's on anymore.
Is that Julie King's name I see there?
It sure is. I'll turn my video on for just a second so I can say hi.
Hey, Julie, I haven't seen you in forever.
I know. How are you?
Welcome. Welcome.
But yeah, the camera's going to be going off because I'm no
What?
on the camera.
No. Keep the camera on. Come on.
You're in a safe place, Julie.
Yeah. Let me see if I can
Yes.
add some background filters or something here. Although not like I have anything left in my office.
I invite the rest of you to turn your cameras on. Be brave. Be brave souls with the rest of us.
Peer pressure. It's not fair.
There we go. You can blur the background. Okay. There we go.
I think we can get started. Michelle, how do you feel?
Okay, let's go ahead and give it a shot, shall we?
Okay. Good afternoon and welcome to the Subcommittee for Technical Assistance for the Governor's Interagency Advisory Council on Homelessness to Housing. The meeting has been publicly noticed in compliance with Nevada's open meeting law, and Chair Michelle Fuller-Hallauer will call the meeting to order.
Good afternoon. It is May 21st, 2024, and I would like to call the, what is this? The Technical Assistance Subcommittee for the Governor's Interagency Council on Homelessness to Housing meeting to order. Shelley, would you please call roll?
Yes. Okay. Chairwoman Michelle Fuller-Hallauer.
Present.
Karen Van Hest.
Present.
Nolga Valadez. Dr. Pamela Janelle. Chris Murphy, which Chris actually let us know he was going to be excused today. Vice Chair Brooke Page. Austin Pollard.
Present.
Christy Costa.
Present.
Lorena Lemus. Scott Benton. Kimberly Martin.
Present.
Adrian Babbitt.
Present.
Julie King.
Present.
All right, Madam Chair, we have quorum.
Woohoo! Thank you. Thank you, Shelley. Okay. And thank you all for being here. I appreciate it. And I appreciate the commitment that you all have for making our meetings so that we do have quorum. It's great that we are able to meet on a regular basis. Let's move on to agenda item number 2, and that is public comment. No action may be taken upon a matter raised until the matter has been specifically added to the agenda. Comments are limited to 3 minutes. If you're making a public comment via phone, please call 1-775-321-6111. The ID is 758-695-708#. We're now open for public comment. Please unmute yourself and state your name for the council. Is there any public comment? Shelley, are you seeing anybody responding?
I am not.
Okay. Seeing none, hearing none, we will go ahead and close this public comment. There is another opportunity for public comment at the end of the this agenda, so we will have another opportunity if you didn't speak up at this point. We will close agenda item number 2 and move on to agenda item number 3, which is for possible action. This is discussion and possible approval of the minutes from April 16th, 2024. of the Interagency Council, Advisory Council on Homelessness Technical Assistance Subcommittee meeting. I believe the minutes were attached to the appointment notice. So is there any discussion around the minutes? If there are none, I will accept a motion to accept the minutes.
Austin Pollard for the record. I make a motion to accept the minutes.
Okay, we have a motion on the table to accept the minutes. Do I have a second?
This is Karen Van Hest. I second that motion.
We have a motion and a second. All those in favor, please unmute yourself and indicate by saying aye.
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 Aye. Any opposed, please unmute yourself and indicate by saying nay. Any abstentions, please unmute yourself and indicate by saying abstain. Motion carries. We will move on to agenda item number 4 for possible action, discussion and possible removal of subcommittee membership for Scott Benson. We have in our bylaws, and Shelley, I'm going to ask you to help me out here if I bungle this up a bit. In our bylaws, we indicate that folks need to attend a certain number of meetings, and if not, that we reach out to them and try to re-engage, which we have done and have not gotten a response from Mr. Benson. And then we reached out to him again since our last meeting to notify him of the putting this item on the agenda, and received notification that he is no longer at that email address. Is that correct, Shelley?
Yes, Chair, that's correct.
And can you remind me of the number of meetings we have to attend and the absences that Mr. Benson has or his attendance record, please?
So for the bylaws that you were referring to, those primarily apply to the council. But because we're the subcommittee, it's just in best interest that we follow those same ones. And so the bylaws for the council indicate that absences of 3 or more would be considered inactive.
And can you tell us in the last year what Mr. Benson's attendance has been?
Yes, he has not joined a committee meeting since September of 2023. And we have a meeting every month.
Yes. So is there any discussion? I'm sorry? No. Any concerns or discussion around this item?
I have one question. Since he's a champion for one of our categories, are we going to end up voting or on having a new champion for? I can't remember which one it was because I'm on it and he was the champion and I was just the co.
That's a great question. I think that Michelle Fuller-Hellower, for the record, I believe that part of our agenda item number 6 is not only to discuss and review our strategic issues, but to do a potential reorganization of the champions for those strategic issues, recognizing that there has been some challenges with some of the champions that and the leadership for some of those strategic issues.
Thank you, Michelle. I did not look down that far on the agenda.
That's fine. Adrian?
Thank you. Adrian Babbitt for the record. I don't know Scott Benton, but I see on LinkedIn that he has his resume posted with his personal Gmail email address. So I'm not sure which, was it his professional email that the outreach was completed?
Yes, it was.
Is there interest in this group in pursuing additional outreach? Like I said, I've never worked with him, so.
Can we hear again the outreach that was done? So just as a refresher, so we can decide whether to do additional outreach.
Shelley?
Sure. So Shelley Aguilar for the record. Prior to my role on this committee, the previous individual, Niani Cooper, she reached out to him on 2 separate occasions to ask him about his attendance and his involvement, to which neither he responded. And then when I joined the committee, which this is my 2nd month as part of the subcommittee, I reached out to him via email as well via telephone. And that's when I got his email is no longer active, and the phone number that I called just continuously rang. There was no voicemail or anything to leave a message for him.
Shelley, this is Adrian for the record. Was Niani's outreach prior to December 2023 or after? Do you know?
Yes, let me see if I can pull the email really quickly because there's dates in there. She reached out to him in December of 2023 and also in November of 2023.
Okay. I mean, I don't have strong feelings about it one way or the other, but his resume with his personal email and phone numbers are available online.
This is Michelle Fuller-Hellauer for the record. Shelley, is it accurate that to the best of our knowledge, we were not given any notification that Mr. Benton was not going to continue, that he had no interest in continuing, or that he was changing his role, his professional role?
Yeah, I can confirm there's been no communication with Mr. Benton regarding his role.
And he's not joined a meeting since August? Is that what you said?
Correct.
Julie King for the record, totally acknowledging too that this is my first meeting, but it would seem to me if there's no meetings for 3 months kind of rule, if you will, and outreach did happen on multiple occasions after those 3 months had passed. And there was probably, we don't really know exactly how much time passed between the last outreach in December and then what happened in 2024. I don't know. It would seem to me that it would be appropriate to remove him from the subcommittee at this point.
Thank you, Julie. Any thoughts on that? Any comments, discussion?
Karen Van Hest for the record, and I have to agree with Julie. Because I've tried reaching out to him on a different level, because he actually was working right down the street from me, and then being on the same strategic plan, and there was no communication whatsoever.
Any other discussion on this item? If there's no other discussion, I'll take a motion.
This is Karen Van Hest for the record. I make a motion to remove Scott Benton from our subcommittee.
Okay. And we have a motion on the table. Do I have a second?
This is Julie King. I second that motion.
We have a motion and a second. All those in favor, please unmute yourself and indicate by saying aye.
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 All those opposed, please unmute yourself and indicate by saying nay. Any abstentions, please unmute yourself and indicate by saying abstain. Motion carries. Okay, we'll close agenda item number 4. Agenda item number 5. This is a for information only item. This is particularly for our new members of the Interagency Council on Homelessness to Housing Technical Assistance, but hopefully our continuing members will find this helpful as well. This is a new member orientation. So Shelley and I will tag team this orientation for you. So sit back, relax, but don't go to sleep.
Well, that was perfect. Okay, let me get my screen sharing set up so I do the right thing here. Okay. Can everybody see my screen? Okay, perfect. I'm not going to be able to see or hear you guys, but the rest of my team will chime in case anybody has a question or needs something. So, as Michelle said, this is our presentation for our new member orientation, but I know that our DAG was especially excited. He's our Attorney General. He was especially excited that we are going to review the open meeting laws with everyone. So even if we've been on the subcommittee for a while, we will be able to review some stuff to keep it fresh in our brains to make sure that we're compliant. So for this presentation, we're going to review Nevada's open meeting law, the NRS for the Interagency Advisory Council on Homelessness to Housing, Robert's Rules of Orders, subcommittee expectations, what is the Interagency Advisory Council on Homelessness to Housing, and the strategic plan for our subcommittee for technical assistance. So just to keep it point to where it is, the Nevada Revised Statutes, Chapter 241 is what discusses the open meeting laws for Nevada. And it states, in enacting this chapter, the legislature finds and declares that all public bodies exist to aid in the conduct of the people's business. It is the intent of the law that their actions be taken openly and that their deliberations be conducted openly. So for that reason, we need to make sure that we notify individuals that we have the meeting and that they will, and that everything will be discussed. So this presentation is a pre-recorded training that's provided by our Chief Deputy Attorney General, Rosalie Bordalove. I'm going to just play the training so we can all sit back and learn from her. So I just ask that you please keep your questions until the very end. And Michelle, I can see you. So if, oh no, well, that's not good. It worked this morning. Let's see. Let's try something different then. Let me try and see if the link, I might have to email it to you guys instead. Oh, that one worked. Okay. Okay.
Good morning, everyone. My name is Rosalie Bordilov. I'm Chief of the Boards and Open Government Division with Nevada Attorney General's Office. And we house the Open Meeting Law Enforcement Unit within the Attorney General's Office, as well as representing many state agencies. I'm sure we represent many of the boards and commissions who have representation here today. I'm going to give a general overview of Nevada's open meeting law. I'm going to hit some of the areas of what needs to be complied with, both from the members of public body perspective as well as staff. As with homeless presentation, I'm going to encourage you reach out to me if you have questions, or your counsel, as for state public bodies, the AG's office represents them, and our DAGs are well-versed on the open meeting law and always available to help. So to start with, Nevada's open meeting law is housed in NRS Chapter 241. It requires that public bodies take their actions openly and that their deliberations be conducted openly. This is the stated intent by the legislature and guides the interpretation of the law, both by the Attorney General's office and by the courts. When coming to it applying, the first step is knowing whether you're a public body. Many of you probably know that's a given, but there is a definition that is fairly detailed for the term public body within the OML. Generally, though, public bodies are bodies created by statute, executive order, or by action of another public body. This includes subcommittees and can even include the governing boards of some corporations, more likely nonprofit corporations, but either way, if they meet the creation requirements contained in the open meeting law. So if you're ever unsure if you are a public body, consult your legal counsel. An analysis can be done. Frequently, that's our office. That's something we frequently are doing. It really involves creation by government with a government function. That's the intent of these public body provisions, is to capture bodies that are making collective decisions regarding government and expending state money. That's what their goal is to capture. And the goal of the law is that the deliberations, the reasons behind those decisions and that decision-making process is open to the public, and that the public has the ability to come and have their voice be heard in front of those bodies. So the public comment, which I'll talk about the requirements regarding it later, is really that avenue so public can come and be heard regarding how they want their money to be spent in government and how tax dollars should be spent. There are some exceptions to the general mandate, a few of which I'll discuss, but the Nevada Supreme Court has stated that the spirit and policy behind the open meeting law favors open meetings, and any exceptions thereto should be strictly construed. There are specific exceptions for specific bodies. There are also some exceptions I'll talk about within the law that apply to all bodies, but only for certain topic or certain areas where they're exempted from the OML. So once you know if you're a public body, the next question is, when a gathering of members of a public body occurs, is it a meeting under the definitions in the law requiring notice, open to the public, and all the other requirements in the chapter? Under the OML, a meeting requires a quorum of members together with either deliberation or action. So Nevada is a strict quorum state, which means a quorum of members must be present in order for the public body to take action and in order for it to constitute a meeting. Under the open meeting law's general definition, a quorum means a simple majority of the total body or another proportion established by law. So the legal authority creating the public body frequently will have, whether it be statute, executive order, some provision in it that says a quorum is this many people. And so if you have one of those provisions, a separate statute, that will control and define what a quorum is for your public body. But if the legal authority creating your public body is silent with respect to quorum, then it defaults to this simple majority. For action, it is a majority vote of members present. That is the general for most bodies. However, if all members of a public body are required to be elected officials, examples of this would be county commissions, city councils, then action requires a majority vote of all members of the entire body, regardless of who are present. So if you have a 7-member body that is all elected, you may have 4 present, which constitutes a quorum. You still need those 4 to be unanimous in order to take action because 4 is still a majority. However, if it's an appointed body, as opposed to being elected, 4 members could be a quorum and 3, an affirmative vote of 3, because that's a majority of the 4 present, would be able to act. So that's an important way to distinguish between the elected bodies and the appointed. There was also an update from the 2023 legislative session, and I'll kind of consolidate and talk about these updates at the end as well, but I like to kind of pepper them through where they're relevant. Vacancies no longer count when calculating a quorum for appointed bodies. They still will count with elected bodies. The reason behind this difference is because elected bodies usually have additional provisions where they can appoint themselves a member until the next election or a special election can be held. But there are many public bodies within state government where the governor appoints the members, and their reason for vacancies sometimes has to do with a lack of applicants or a lack of qualified applicants, which means it can be a little harder for those vacancies to be filled and can make it very difficult for the bodies to function when they're lacking members. The main exception to that quorum requirement and the number required for action is contained in the ethics law, which you have a presentation on later. But in general, if a member is abstaining from voting on a matter due to an ethical conflict under the provisions of NRS Chapter 281A, then they are removed from the quorum requirement and the number required for action as if they're not a member of the body. So the number required is reduced as if they're not there if they need to make that recusal. And I'll just do a note, it's on the slide here, but I want to make sure, especially if people aren't able to see. Deliberation, which you can have a meeting even if there's no action. Deliberation means collectively to examine, weigh, and reflect upon the reasons for or against an action. So it's kind of important to note in the next slide, I'll get into why that deliberation is important, but that's the definition there. It's really walking towards that decision, even if a public body doesn't conclude the discussion with a vote. So to kind of flesh that out a bit, a gathering of members at a social function, a training, at really any event, a gathering of a quorum is only a meeting if that deliberation or action is occurring. So frequently with local government bodies, maybe a city council, the members are going to all be present at the town fair, or there's other town events that you may have a quorum present simply because they're all members of the community, they're active in their community. That does not trigger the open meeting law unless they start discussing as a quorum the reasons for or against an action that's going to come before them, that's within their jurisdiction and control. The instruction I often give to public body members is if a quorum of you is going to be present at a function, don't talk shop. You know, you can talk pleasantries, you can talk about news, but don't really get into your public body's business, and just kind of avoid those discussions, and you won't cross into that deliberation line and violate the OML. Because most likely those are going to occur mistakenly, unintentionally, but it still could be a violation. The main exception here, and is a very important exception, is the attorney-client conference. When a public body meets with its attorney to discuss potential or existing litigation, they can meet as a quorum, they can deliberate regarding a decision. And this can all occur outside of a meeting. It's a complete exception to the definition of a meeting, which means they do not need to issue an agenda. They do not need to open it to the public. It does not need to be recorded. This differs from a closed session, which I will discuss later. There are other provisions required for closed session, but the attorney-client conference exists to protect the attorney-client privilege. While in the interest of transparency, many public bodies, and we often recommend that they include an item on the agenda that they're going to go discuss a specific litigation with their attorney, receive an update. That is completely permissible. And there's no harm. We definitely favor and recommend more transparency, more public access. But if you need to be able to protect that attorney-client privilege, the exception exists. And while public bodies are permitted to deliberate during this attorney-client session, any action still must occur during a public meeting. So that deliberation could even include polling. We recently issued an opinion finding that deliberation could include expressing opinions on how you're going to vote. However, action is defined as occurring during a public meeting. So to the extent an attorney needs to be able to get client consent from this public body to file a lawsuit or settle a lawsuit or file an appeal, those are the big ones, they have to get that consent during a public meeting. The public needs to be aware of what decision was made. So frequently what will occur is an agenda item will be listed to take whatever action it is regarding this litigation. The public body will meet in private, get briefed on from their attorney regarding the decision. They may even deliberate about it. That's kind of to protect their ability to enter into settlement negotiations without having to lay all their cards on the table in public prior to the negotiation. But in order for that action actually to occur, it must happen during a public meeting. A point I'll make also to that attorney-client conference, as the law has changed over the last few years regarding this a bit. There was a Nevada Supreme Court decision in 2018 that found that you really can't, anything requiring client consent has to occur during that, has to be action. There is no implied consent, and no consent can occur ahead of time privately and then be ratified later. In response to that, the 2019 legislature added a provision allowing public bodies to delegate litigation decisions to their chair or executive director or equivalent position. The delegation itself must occur at a public meeting. It can happen before the fact. It could be a broad delegation regarding litigation decisions. It could be a very specific delegation. I often recommend bodies that I represent to be more specific and include some provision regarding reporting back to them so public is aware of what decisions have been made behind closed doors and the public body is apprised of what decisions have been made, what is going on with the litigation that they're a party to. However, the provision is in there specifically allowing it, and you can have these delegations. Some bodies have very, very broad delegations that simply allow their chair to make any litigation decision outside of a meeting in conjunction with their counsel. Another area that frequently can get to mistaken violations is electronic communications. You can have a meeting occur where the members aren't all present physically in one place, or even communicating at one time. An email chain where all members or a quorum of members are on an email chain, emailing back and forth regarding a matter within the jurisdiction and control of the public body could constitute a meeting if those communications constitute deliberation. And the main pitfall with that is one member or staff member sending out an email regarding an issue and then members clicking reply all so everyone sees it. To avoid that, the recommendation I often give is that if a staff is going to send an email to all members to push out some information, raise an issue, say, look, this is becoming an issue? Do you want this on the next agenda? Whatever it is, we recommend that they BCC all the members. So simply the ability to click reply all isn't there. Or email it members individually. It's an easy step that just means those members, when they're not thinking about it, because they're used to, many members, especially as state bodies are appointed, they're within a profession. They have a day job that's in the corporate world or otherwise in the private sector where this open meeting law doesn't apply. And they're used to being able to click all, reply all, and kind of get business done in that way. And that just doesn't work in the public body sphere. And so that's an easy step. Another point that members need to be cautious of, and staff members as well, is walking quorums or serial communications, which can constitute what we call a constructive meeting. And what that is, it's when less than a quorum speak together about an issue. And then somebody from that less than quorum group goes and speaks with another member or another couple members, such that at some point a collective discussion has occurred between a quorum of members, even if it was piecemeal. And that can, again, mistakenly, and it's important that members be instructed so they understand this. The best way to kind of explain is a example. Say you have a 7-member body. 3 members meet in the hall after a meeting. They discuss an issue that just came up during public comment. It's something that's relevant. It's something they're likely going to want to put on an agenda later. And they talk about, what can we do about this issue? You know, this is a big problem in our community. Let's start brainstorming ideas. They're 3 members. So while they are deliberating, 3 members don't constitute a quorum. They haven't violated anything yet. However, they speak for a little while. They decide, okay, we'll revisit this at the next meeting. We'll ask for it to be on the agenda. We'll talk about it then. Then one member of those prior 3, right? We have members A, B, and C talking. Member A goes and talks with member D a week later. They run into each other at the grocery store. They start talking about this issue that came up during public comment. And member A says, yeah, I was talking with members B and C. They had these ideas. I think they're really good ideas. We're going to have this on the next agenda. But what do you think? They were thinking that this might be good. Here's some options. And they get into depth. They're 2 members deliberating. Members A and D are not a quorum. However, member A has conveyed the opinions and the facts that are reflecting on potential decision in the future to member D. So members A and D have kind of had this collective conversation with members B and C, and now they're a quorum, and that would violate the open meeting law. And the reason behind this is because when they then get those 4 members, along with say 2 more, because one's absent, 6 members are present at the next meeting. And those 4 members get up there and say, yeah, we've talked, and there's these couple areas that we really think are best, and they really don't talk about why, because they've already had this conversation. And they propose these things that they already brainstormed, and they go ahead and pass it, and that's the decision. Well, the public didn't have access to those prior conversations. So now these deliberations and reasons behind this public decision, public expenditure of funds, occurred outside of an open meeting. And that's where the violation occurs, is because the public has right to that access, or right to observe their government process. So we now know when it applies. The next question is, how do you comply? If you know that you have a meeting, you need to have a public notice agenda that includes the time, place, and location of the meeting, or if it's an entirely virtual meeting, which is permitted for appointed bodies in certain circumstances, though there are some exceptions to that. Information on how to access the remote technology system if it's a virtual meeting needs to be on the agenda. So a link, this is how you get there, as well as a phone number. A phone number is required for entirely virtual meetings. If it's an entirely physical meeting, you don't need any, you're not required to include that electronic access. But if it is entirely virtual, the public needs to be able to access in the same way. The name, contact, and business address for supporting material, a person from whom supporting material can be requested plus a location, either physical or a website where supporting material can be received. Clear and complete statement, and I'll talk a little bit of what that means later, of topics scheduled to be considered must be on the agenda. Any agenda items that action may be taken should be denoted as for possible action. Those 3 words are in quotes in the law. So I really request that you use those 3 words somewhere next to the item on the agenda. As well as public comment periods need to be listed, and any restrictions on public comment need to be listed on the agenda. These requirements can all be found in NRS 241.020. They're laid out fairly specifically. So any staff members who are putting together these agendas, I highly recommend you just kind of read through that statutory provision because they get pretty specific. And then when it comes to posting this agenda, it needs to be posted at the office of the public body or the location of the meeting, the public body's website if it maintains one, and Nevada's public notice website, which is notice.nv.gov. All this posting needs to occur no later than 9 a.m. of the 3rd working day before the meeting. So to the extent that some of these websites may take time to refresh, you need to plan ahead such that the posting is, you reasonably believe the posting is going to be available and by 9 a.m. Notice must also be sent to persons who've requested notice of meetings. That can be electronically if they prefer electronic, or by mail if they request it by mail. If they request it by mail, it needs to be deposited with the mail service by 9 a.m. or put in an outgoing mailbox that is expected to be picked up before 9 a.m. So you need to reasonably believe that it is in the possession of the U.S. Postal Service by 9 a.m. or whatever postal service you're using. If that service then has a delay that's out of your control, there's exceptions there. But we've even had complaints regarding mailing and postmarks being after 9 a.m. So that's where the line's been drawn, is it needs to be, you need to reasonably believe that the post office will pick it up by 9 a.m. There's some additional requirements regarding the combining of agenda items and the inclusion of names of persons who may be discussed or acted upon. Again, those can be found in 241.020. In general, if you're going to take administrative action regarding a person, their name needs to be on the agenda. There's a couple exceptions to that. There was also an update from the 2023 session that requires clear instructions for telephonic public comment to be listed on an agenda. This is if the meeting is entirely virtual. I also want to note that a higher degree of specificity is required for agenda items of substantial public interest in order to meet the clear and complete standard. So there's no definition as to what substantial public interest is because it's different. It's very fact specific and it's different for every public body. But things to ask is this topic generating a lot of press? Do you anticipate a lot of public attendance, a lot of public comment on this matter? Is it a contract or otherwise an approval of an expenditure of funds that in relation to that public body is a very large expenditure of funds? So where that varies is, I represent the Nevada Board of Examiners. They frequently are approving 50 plus contracts per meeting. And many of those contracts are over $1 million, but that is the entire state's budget. So $1 million contract for the Board of Examiners is not likely to be of substantial public interest, although there is a lot of detail listed for each contract in their agendas and materials. But a small town board approving a $2 million contract may be of substantial public interest because that is likely to be a very large portion of their budget and is likely to be a large percentage of the tax revenue that they receive. So it's important to just kind of look at the item in that sense. When in doubt, I recommend more detail on your agenda, especially if it's an expenditure of funds. Putting minimums or maximums that this is they're going to decide whether to approve this a contract or not to exceed a certain amount. It is okay if you put an amount on the agenda and they end up approving an amount lower than that, but it was a reasonable guess, and they end up saying, yeah, we're going to make an approval, but we're going to spend less money. Usually you're going to be okay there. But if they say we're going to do up to this amount and then they end up approving as an expenditure of more money than was stated on the agenda, you might be in trouble. So again, the more detail, the better. It is frequent to have agenda items such as member comments or an executive director's report, legal counsel's report. It's just a standing general item like that with very little detail. I give a little caution on those items, though I wouldn't say that they do not per se violate the law in any way. The worry with those items is that they don't have any description of what's going to be discussed. To the extent that they are a staff report or a member comment, and that's really all they are, then they're perfectly permissible. And I just ask that you keep them to that, essentially a news report. This has been what's been going on. A member comes up and says, I've been speaking with constituents and this is the feedback I've been getting. I would like these items on a future agenda. Or the executive director says, over the past quarter, these are the, this is how many licenses we've approved. This is what's been going on the day to day. This is the staffing that's happened. That information is all fine because that is truly a report. But if some issue raises the attention of members and they start discussing it, as legal counsel, when I'm present at meetings, I'm going to stop them if they really start walking towards a decision. They start walking towards what they want to do about this problem, because that's deliberation. And now they're deliberating on something that's not in detail on the agenda. So with those reports, I ask that they be kept to just reports. And the recommendation is, if an item is raised that members would like to talk more about or maybe take action on, they request it to be an item on the next agenda. And then it can be more fleshed out and put in detail at that time. Some other requirements not specific to the agenda, but in complying. Public bodies must make reasonable efforts to assist and accommodate persons with physical disabilities desiring to attend. Many public bodies put a contact person on their agenda for that purpose. Sometimes they have deadlines for when a request for accommodation must be made. That's permissible. The only thing I would say is, if you have a deadline and a request comes in after the deadline, if you can reasonably accommodate that request after the deadline, attempts should be made. But it'll go to the reasonableness if you have made people available. If the request is made by a certain deadline, you'll be able to accommodate, and it comes in later, you might not be able to, and it adds to that reasonableness. Additional notice is also required for consideration of a person's character, misconduct, competence, or to take administrative action against a person. This additional notice requirement can be as long as 2 weeks, depending on the type of notice chosen. So it's important to plan ahead when considering a person's character or taking discipline on a license, as many of our state agencies do. However, this notice has always been considered to be waivable. So if the person is in agreement that the matter is going to be heard on a certain date, I often recommend get that waiver in writing, whether it be email, something, so that you can show that it was waived at a later date. You can have something heard on a shorter notice with a waiver. The notice periods did change in 2023. So the new notice requirements are a little bit shorter. And so if you have procedures in place to comply with the old ones, this will not result in a violation. You'll be doing okay. But the notice requirements were shortened a little bit, and even shorter for employees of bodies, but it's a little bit different in how they're done. Because taking discipline or that kind of thing is usually something that has the potential to be contested, we often recommend that you consult your legal counsel for the notice, and they're often the ones sending the notice anyway. All meetings must be recorded or transcribed. That is the difference between closed sessions and attorney-client sessions. Closed sessions are meetings. They must be recorded or transcribed. Minutes of meetings must also be kept in conformance with 241.035. There's some details in there as to what needs to be in the minutes, but it's largely details on who was present, what was talked about, what action was taken. There are also deadlines within which minutes must be made available to the public, so prepared and approved. Those are contained also in 241.035. Generally, minutes need, at least draft minutes need to be available to the public within 30 working days. And then the minutes need to be approved within 45 days or the next meeting of the public body, whichever is later. Supporting material is another important area. It's required to be available to the public at the same time it's provided to members of the public body. Supporting material means material that has been provided to a quorum of the public body by a member or staff member of the body, and that members would reasonably rely on to deliberate or take action on a matter contained in a published agenda. The definition was actually added in 2019. It's specific in the law, so it's helpful to read that if you're ever unsure if a document is. It can be found in 241.015 with the other definitions. We get a lot of complaints and questions regarding supporting material, especially in today's environment of virtual meetings. There is no requirement in the law that supporting material exist. So there's no minimum amount of documents that a public body member is required to review or required to have prior to deciding on their vote on an action item. However, if documents have been given to a quorum of members that they are reviewing for it, those documents need to be available to the public. The new definition, not that new, it's now 4 years old, but the definition in the law means that a document does not become supporting material until it's both been provided to members and the matter it relates to has been included on an agenda. So there are times when a board book may go out to members before the agenda has been posted. At that point, and with virtual meetings, because virtual meetings, you do have to post supporting material on the internet, the supporting material needs to go up with the agenda because it doesn't meet the definition until that agenda is posted. It also means that a document that has been provided to members that may not have been intended to be supporting material could later become supporting material when something gets added to the agenda. An example I'll give is a member of a public body sees a news article or other report that she feels is very relevant to the body, sends it out to all the other members and says, I think you guys should take a look at this. Maybe this is something we should be doing something about. The other members look at it. At this point, it's gone to a quorum, but it's not supporting material. But then enough members look at it that they say, you're right, we should do something about this. Let's put it on our next agenda. At the time the agenda is then posted, it becomes supporting material because they decided they want to do something, they want to deliberate on this item. So the request for members is that if you're going to circulate documents like that, you make sure your staff is aware of them because they may need to include those documents in packets later. The other note I will give is if a meeting has a physical location, a copy of that supporting material, one copy needs to be available at the physical location, but it does not have to be posted online. If there is no physical location, it does need to be posted online. I always recommend if the public body has the capacity and has the website, the ability to post their supporting material online, it cuts down on supporting material requests. Frequently, you can simply send a link. It allows for more public access. It's definitely something I would recommend, but there are reasons at times that can be difficult. So that's there. I will also note that just because an item may not yet be supporting material, that does not mean that it's not a public record that can be requested through the public records process. And you'll get the next presentation is actually on public records. So supporting material must be available to the public at the meeting. It's got a lot of requirements. It also needs to be given to the public upon request at no charge. There are areas in the public records law under public records request where you may be able to charge for some public records when giving them out. So it's kind of important to note if it falls under the OML, it does have to be provided at no charge. If it doesn't fall under the OML, it still may be a public record. and then you can review it under that public records process. And the other note I'll give, the last point on here is regarding emergency meetings. Emergency meetings may only be called where the need to act upon a matter is truly unforeseen and circumstances dictate immediate action is required. So prior to the COVID-19 pandemic, it was very, very rare that I ever saw an emergency meeting, or any client of our office would request, would ask, can we hold an emergency meeting in this circumstance? It was rare because they almost always, you could have this notice. However, those increased a lot during the pandemic because immediate action needed to be taken regarding many matters. It needs to be something truly unforeseen. An example I will give has to do with a licensing board, and this was actually before the pandemic. They licensed interns as part of the profession they regulated. Interns needed to be licensed, and the approval of their license, they were approved with their specific supervisor. And if their supervisor was changed, they had to come back to the board and get reapproved. And it was a health profession, and they saw patients, and a supervisor unexpectedly passed away. And that supervisor supervised a number of interns. So these interns had appointments scheduled with patients, and they could not see these patients. And this was not to the benefit of Nevada. They needed access to healthcare professionals, but they no longer could legally see them because they didn't have a supervisor. So the board held an emergency meeting. What they did, and what we always recommend doing, is if you're going to do an emergency meeting, comply with as much of the OML as you can. And usually what you can't comply with is the 3-day notice requirement. So they did a meeting on 24 hours notice, and they posted their agenda, they sent out notices, they did everything they could, but on 24 hours notice, they held a meeting, they took public comment, it was open to the public, and the only action item was approving new supervisors for these interns so that they could see the patients who had scheduled appointments and move forward. And the important note there is this was something truly unforeseen, and the only thing on the agenda was what the action that needed to be taken because of the emergency. And that's the important to note, is you may have a reason to have an emergency meeting. You can't add other things to the agenda. You said, oh, well, we also need to do this other stuff. And since we're going to get together for a meeting, let's just do it. If those action items can be delayed until you've given 3 days notice, then they need to be. And one note that I forgot on minutes actually is I'm frequently asked whether a member who is not present at a prior meeting can vote to approve the minutes of that meeting. The answer is yes. As far as the law is concerned, and I know many bodies follow Robert's Rules of Order, which has different provisions. Robert's Rules of Order is a great resource for bodies that are looking for parliamentary procedure because it's not addressed in the open meeting law, but it is not required by the law. And as far as the law is concerned, the body just needs to be able to approve minutes as the official record of that meeting. So if a member wasn't present, many will state a qualifier on the record regarding their absence prior to voting. This is helpful. It's not required, but they can vote to make these minutes the official minutes so that they comply with the law on approving. This usually only becomes a problem when the next meeting of the public body is after that 45 days, or there won't be another meeting within the 45 days. They need to approve minutes to comply with the law, but if there are members absent, so if those who weren't present at the prior meeting don't vote, they can't pass the minutes. And that's usually when I say, look, go ahead and pass these minutes. You're making it the official record so public has access. So public comment is a very, very important part of public meetings. And it is an area where we get probably some of the most complaints to our office regarding violations of the law. There are 2 options to meet the minimum requirements for public comment. The first would be to have the 2-period format that is most common with public bodies, which is a general public comment period at the beginning. It could be limited to items on the agenda, or it could be simply anything within the jurisdiction and control of the public body, but it needs to be prior to any action items. And then another public comment period sometime near the end of the meeting that is general on anything within the jurisdiction and control of the public body. That public gets there. The other option is, instead of that first public comment period, you can have comment on each action item prior to discussion, but before the vote. You still need to have that second general period at some point prior to adjournment. I often recommend the 2-period option because it's easiest to meet that minimum requirement. And there is nothing in the law that prevents a public body from taking more public comment than is listed on their agenda. But you need to list at least enough to meet the minimum requirement on the agenda and take public comment at those periods. But you can go ahead and have a general one, but then say, I know we've got a really hot button issue. We're going to take comments specific to that issue when we get there. And then go ahead and take that then, and that's fine. The main goal is that public needs to have an opportunity to be heard on action items prior to the body taking the action. They need to be able to voice their opinions. This is how we want you to act. Public body doesn't have to act the way all the public says, but they need to be able to get that input from their public. Any restrictions on public comment need to be listed on the agenda. They may be reasonable time, place, and manner restrictions. And this is listed in the open meeting law. This is also protection of, our constitutional protections of free speech. The public comment periods in public meetings are a limited public forum. So the most common limit you see is time limits. Each person gets 3 minutes or something of the sort. It needs to be a reasonable time limit. You can say you need to come up to the mic, you need to face everybody. You can request that people fill out comment cards ahead of time so that or state their name on the record. Those are all time, place, manner restrictions. They need to be applied in a viewpoint neutral way, and any restrictions themselves need to be viewpoint neutral. This is the public body, the public's opportunity to air their grievances, and they are protected in being able to get up there and complain about their government representatives. This is their opportunity to do that. They can also praise them. Both have to be allowed. I know that there have been issues increasing over the last few years with public comment there being some hate speech, there being other issues. When it comes to further restrictions, we ask that you usually work with your legal counsel. There are things you can do. Speech that is not protected by the First Amendment can be restricted sometimes in other ways. There can be content-based restrictions. They just can't be viewpoint-based. The OML in general, the main provision or tool that chairs have if public comment or other public attendees are getting unruly is the OML does not prevent the removal of a person who willfully disrupts the meeting to the extent that its orderly conduct is made impractical.
Rosalie, can I ask a question?
Sure.
When you were talking about the option where you can either do beginning or end, but you can always do more than what's required. If you are going to do more than what's required, if you've agendized a beginning public comment period and an end public comment period, but like the scenario you described where maybe there's one scenario that is, or there's one of the items that is a hot button item and it's an action item and you're going to do a beginning and an end, but you're also going to allow some comment on a particular action item. Does it have to be agendized that way? So the way you framed it was you can always do more than what the law requires, but do you have to have agendized it that way? If you've agendized a beginning period and an end period, the 2-period method, but then the commission or the body decides it wants to take some comment on a particular action item during the discussion of that action item, does it have to have agendized it that way?
In order to add the public comment period, it does not have to be on the agenda. However, if you would like to be able to tell people during that first general public comment period that they cannot speak on that one item because they need to speak on it later, I would recommend that being in the agenda, because it's possible somebody planned to come at the beginning of the meeting, make their public comment, and is not able to stay till later. And because that wasn't on the agenda, they don't have notice. So my recommendation would be, if you plan on preventing it, however, you could always say, we will be holding an item. We have decided we got so many comment cards that people want to comment on agenda number 5. We've decided that we will hold an additional public comment period during agenda item number 5. If you would like to reserve your comments on agenda number 5 to that period, you are welcome to. We request that you do, or something like that. But if you're unable, I would recommend permitting them to still do it at that first public comment period if you haven't agendized that later one.
Okay, thanks. Appreciate that.
So the main tool you have, if public is in controlling the meeting, is the open meeting law specifically does not prevent the removal of a person who willfully disrupts the meeting to the extent that its orderly conduct is made impractical. And I often ask chairs to look closely at that language regarding removal, as it's an important standard, but does give some flexibility to a chair when running a meeting. And it is at the chair's discretion whether or not the person is being disruptive. I often recommend that my chairs give warnings ahead of time, but there are definitely times that we have seen people be removed from meetings and we've received complaints and upheld it. Again, this cannot be exercised in a viewpoint-based way, but to the extent that somebody is refusing to halt their comment after their time limit has expired and everybody's given the same time limit, they can be asked to stop, and if they completely refuse, you can remove them from the meeting. You can cut their mic, you can remove them. That's kind of your tools to do. If they are yelling or otherwise being very disruptive during non-public comment periods, they can be asked to leave the meeting. So it's not something that I see exercised very frequently, but I have definitely seen it occur, and it can be a necessary thing. A note in there that is new for 2023, if you are using a remote technology system to conduct the meeting, you need to offer at least telephonic public comment. These new requirements can be found in AB 219. I'll note later, I think I list both bills, but AB 52 and AB 219 of the 2023 legislative session are the 2 bills that made these changes. They are not yet up on the online NRS 241, so that's where you can find some of them. There's a summary of the changes on a couple of my last slides as well, that those will go up on our website. So I mentioned closed sessions before as being different from the attorney-client session or other exceptions to the definition of a meeting. A closed session is part of the meeting. But it is a part of the meeting where you can ask the general public to leave. Closed sessions may be held by a public body to consider the character, alleged misconduct, professional competence, or physical or mental health of a person, or to grade examinations. There may be other areas across the NRS where closed session is permitted. This is where it's permitted under the open meeting law. The exceptions would be the appointment of a member to a public body, or considering the chief officer of the body or agency, like an executive director, executive secretary, similar position, county manager, a city manager, those types of positions. You cannot consider their professional competence outside of the public session. You can't go into closed session for those. It can be uncomfortable at times because usually the public body is the employer of these positions, and you conduct annual reviews. And I know in the private sector, and in a lot of places in the public sector, those types of annual employment reviews usually occur in private. They're confidential. That is not the case for these specific positions, and it's something that needs to be known. If you do go into closed session to discuss somebody's character, the action must still occur during the public meeting. But you can have that discussion and talk about, and most often it's seen when approving licenses and there's maybe a history of discipline for a person, and they want to be able to give some background as to that history, whether it be a substance abuse issue, whatever it is, and the public body will agree and go into closed session, get facts on that, kind of hear the explanation, and then come back into open session to make their decision. The other note I'll give to that is either side, nobody is ever required to go into closed session. Either side may require it to be open. If the person who's being discussed wants it to be open, it can be open. If the public body wants it to be open, it can be open. Both parties have to want it to be closed. And if it's closed, the person who's being discussed is entitled to be there along with their representation. For virtual meetings, members of public bodies may attend virtually so long as a physical location for the public to attend is provided. That's for specifically, and when I added that, I don't think I properly edited that, but when you have a physical location, you do not have to provide other virtual options to the public, even if you have members of the public body attending virtually. If you give that physical location to the public, you're fine there, with the exception being if you have members attending virtually and conducting the meeting in that way, you need to offer telephonic public comment, but there isn't really other telephonic options you need to give. If you are doing an entirely virtual meeting, which is available to bodies who have at least some appointed members, if they're all elected, you must have a physical location. But if you have an entirely virtual meeting, you need to give that virtual attendance to the public, regardless of whether there is a physical location for the public needs to be able to hear and observe to the same level as members. So if you have a physical location and a lot of members are attending virtually, there needs to be screens in the room so that the public can see the same screens that the members are seeing. The main pitfall I'll note in there are chat functions in Zoom and some of those other platforms. My recommendation usually is that they be disabled if they can be, or be reserved for communicating with staff regarding technical difficulties, but that you request that public body members not put comments in there. Because if they do, that could lead to being part of the meeting. That's discussion. It could be deliberation. You then have to have a way of recording it. The public has to be able to see it. It has to be kept part of the record of the meeting. So my recommendation is usually to avoid using it where you can. Then you avoid those difficulties of having discussion potentially occur within the chat. So what happens if the OML has been violated? Any action taken in violation of the OML is void. Our office has authority to investigate and prosecute violations of the open meeting law. There's also a private right of action for somebody whose been denied a right under the law, and they could file in court to have something declared void. If you know that there's been a violation or believe that maybe there was a violation, corrective action is recommended. It may not eliminate the violation, but it can mitigate the severity and further ensure that the business of government is accomplished in the open. So what that actually means is you've learned that after the meeting, you learn that your agenda didn't actually get posted to Nevada's notice website, and you had a short meeting, it didn't get posted there, and it wasn't on your website. Public wasn't able to come. If within 30 days, you agendize a new meeting where you redo all those items, you get it posted correctly, everything occurs. Two things happen. One, we will likely decide if we get a complaint, we're going to look at the fact that you redid everything. We're not going to go to court and try and void anything because you've already redone it. And it's going to be taken into consideration to the extent that we are going to issue any opinion on it. We're going to say, well, look, they took this corrective action. They already fixed it. The other thing is there's a 60-day statute of limitations if there's been a violation of the OML for either our office or a private party to go to court and have an action declared void. If you've redone that action already, not only does it remove the need for anybody to go to court? You also can act on the later action. So even if they get your first one voided, you have this later proper action that you can rely on and you can move forward on. I will note two big areas where I see when corrective actions taken that are often lacking is for possible corrective action needs to be put in quotes. Where you would put for possible action, it needs to say for possible corrective action on the agenda. It's a nitpicky requirement, but again, it's in quotes, it's in the law, it's specific. The other is it requires an independent deliberative process. So what that means is you can't simply say, oh, we realized last time we did something wrong, so let's take a new vote, take the vote. But you spent an hour deliberating on how you wanted to do this and what you wanted to do and why you wanted to do it at that prior meeting. You need to redo that, especially if public was prevented. So you took this action and you deliberated, but you didn't have the proper public input. So when you redo the meeting, you need to get that public input and then you need to redo the consideration. And it can't just be a rubber stamp of the prior action because that public input needs to have the opportunity to be considered. And then I realize I'm running out of time, so let me give a quick few updates that I haven't already mentioned on the 2023 legislative session. Again, that was in AB 52 and AB 219. Hopefully soon they'll get updated, but in the online NRS. The quorum definition was updated that only voting members count towards a quorum. That doesn't change for a lot of bodies, but there are a few bodies out there that have some ex officio non-voting members, and it was unclear whether they counted towards quorum calculations. For appointed bodies, vacancies do not count. The definition of a meeting, the language is changed. So you will see some changes to how that's written out in the law. It is not changing the meaning. Before social functions, there were certain things listed as exceptions, but they were only exceptions if there was no deliberation, which meant there were really clarifications because they wouldn't meet the meeting definition. So those have been removed. That doesn't mean that they now have to comply with the OML. It means we're just looking at that. Is there a quorum plus deliberation or action? With the attorney-client conference is the only true exception. It's still in there. It's not changed. There's a new definition for administrative action against a person. That is a term that triggers notice to them and some other requirements in 241.033. It is now defined as an action that is uniquely personal to the person and includes the potential for negative change in circumstances. It is an existing, our office was already giving that interpretation to that term, but it was not defined in the law. So this allows people to kind of rely on that interpretation a little more. Notice to individuals for administrative action against them or consideration of character is changed. Previously, those were found in 241.033 and 241.034. However, because the notice is being separated because it has some other options from notice for real property actions, the numbering will likely change. So I'll try and update this once the Secretary of State's office has everything updated in the online OML and codified. The actual citations to where they are is probably going to change. And all elected bodies may now take advantage of NRS 281A.420 subsection 5's quorum reduction. That's where I talked about abstaining based on the ethics law. You'll hear more about why those abstentions may occur, but previously there were some elected bodies depending on the size of the county they were in, it changed whether or not they could take advantage of this and what type of legal advice they needed. This was changed to apply the same ethical standard across the board. A couple other, and I'll try and be pretty brief, public comment during multi-day meetings. They're now, if you're going to agendize a multi-day meeting, there must be at least 2 public comment periods on each day of the meeting. If you are posting your agenda, the location of the meeting is now alternative posting location if there's a physical location for the meeting, as opposed to the office of the public body. That kind of goes back to where things were pre-2021, but so many bodies may already be doing that. Meetings to consider regulations or contested cases under NRS Chapter 233B must have a physical location for the public. That can't be an entirely virtual meeting. I already discussed most of these public comment during virtual meetings options, and how it must be done. Those changes are in AB 219, but that's kind of a brief summary of what those are. And lastly, as this will go up online, what these links are. The first link there is to where these videos all will be, and these will all be located. There's also a prominent link on the Attorney General's website that says training and materials. If you go there, it is under open government, but on the front page, that is where all of these videos will be. Currently, there are videos up from 2021, and all the videos from today are going to replace those. The second link on there is where you can find opinions. All open meeting law opinions we issue are available on our website. I apologize, there isn't an amazing way to search through them. They're listed by number, but we do continuously post as we issue. You can always call our office with general questions on the open meeting law. There is a DAG on call each day. You'll be able to get a call back within 24 hours or so to answer general questions. We also could frequently point you to specific opinions by number so you can read them that might be relevant to what it is. And the last on there is our open meeting law manual that has a lot more information. It's a little bit out of date, and so I would recommend for general information our this presentation, both the video and the PowerPoint will be up online for information. And with that, I am open to, please contact me. My email is rbordalove@ag.nv.gov. If you have questions, I'm happy to always answer them, especially staff, anyone supporting public bodies. I would much rather you be able to ask some questions and learn about the law so that violations don't occur. Rather than get complaints after the fact because there was just a misunderstanding in the law and something was accidentally violated. So definitely open for questions. Right now, we have a 15-minute break, so you can all stretch your legs, and then we'll be back at 11:15.
Okay.
Okay.
Get back to where we were. Okay. Okay, so that was our training regarding the open meeting laws. And there we go. Just some more information on the Nevada revised statutes. And just to give everybody a heads up, this NRS is specific to the Interagency Advisory Council on Homelessness to Housing. And so like I had mentioned previously in the meeting, that this is written for the primary council, but being the subcommittee, we like to be aware of everything that the primary council should be doing so we can make sure that we're all following in suit with them. So NRS indicates that the council was established in the 80th legislative session through passing of Bill AB 174. And the whole purpose of this council is to coordinate and focus Nevada's efforts to effectively address the challenges of homelessness. And the council will work to increase awareness of homeless issues among state and local government agencies and local organizations to provide services to people who are homeless. So you'll notice that we tend to break down the title of the council into ICHH. And for the subcommittee, we go by ICHHTA, just to shorten things up a bit. Additional pieces of what the council should be doing is the council shall collaborate with state and local agencies and promote cooperation among federal, state, and local agencies to address homelessness. The council shall develop a statewide strategic plan, which Michelle is going to cover later for us. And that plan must be updated every 5 years to include recommendations for actions by state and local agencies, and then also recommendations for legislation. The council shall establish a technical assistance committee, which is us, to provide advice and information to assist the council in developing the strategic plan. The Technical Assistance Committee may include without limitation representatives of federal, state, and local agencies, providers of services, religious organizations, persons involved in the sale or lease of housing, and members of the public. The council shall also increase awareness of issues relating to homelessness among state and local agencies, organizations that provide services to persons who are homeless, and the general public. There are these two responsibilities to submit reports by the council, and those are outlined in NRS 232.4983, and it indicates each year before January 1st, the council must submit a report concerning the activities of the council from the previous year to the governor. And then on every odd numbered year before January 1st, the council must submit a report to the director of the LCB, Legislative Council Bureau, to indicate all of the activities of the council the previous 2 years. So moving from NRS over to Robert's Rules of Orders. Robert's Rule of Orders it was established by Henry M. Robert. And what Henry M. Robert said was, where there is no law, but every man does what is right in his own eyes, there is the lease of real liberty. And so really the whole purpose of Robert's Rules of Order is to make sure that there's consistency and that there's organization and that there's proper handling of meetings and that everybody has their opportunity to discuss. And so the guiding principles of Robert's Rules of Orders are to make sure that everybody has the right to participate in the discussion if they so choose. You're not forced to speak, but you're absolutely welcome to. And that we only discuss one motion at a time so that we can make sure that we stay organized and on topic. It's very important that we all understand appropriate times when it's allowable to interrupt a speaker. And during some examples of those are to obtain information about the business, if it's unable to hear or for safety reasons, if there's a breach of rules, or if there's disagreement with the chair's ruling or call for unanimous consent. And then just some specific pieces about Robert's Rules of Order that pertains to agendas. And kind of this was reviewed a bit by our Chief DAG in that presentation, that public comment allows members to talk about anything. The board may question them, but no further action or discussion is allowed. And except for meetings that provide public comment, there can be no discussion of action on any item that's not on the agenda. The meetings must be preceded by adequate notice, and there may be action on any item on the agenda unless it states for information only. So you'll notice when looking at our agendas that they have that specific verbiage on there so that we're already aware of what we are and aren't reviewing. Robert's Rules of Orders is also known as the parliamentary procedure, and it's just like what we've been saying is a set of codes or rule of ethics to help conduct orderly and productive meetings. These are some of the common actions, what the action would be, and one way that you would be able to kind of kickstart that action, what the appropriate verbiage would be. And for these motions, they have to be supported by another committee member by indicating that they second the motion. As far as expectations for this subcommittee, those are that you be actively involved in participating, including championing a working group, that you attend the meetings regularly, that you follow Robert's Rules of Order. And if you're interested, there's full published books about Robert's Rules of Order, excuse me, not just those few slides that I had, but there's a whole book on it that you're welcome to read. The further expectations are that you identify any conflicts of interest on an item prior to voting, and that you recuse yourself from speaking or voting on any agenda item prior to the beginning of the agenda item, and the reason it's inappropriate for you to participate. So moving along, I will pass the baton to Chair Michelle to talk about the council.
Okay, thank you, Shelley. That was very, very informative. And so let's talk about the mission and vision of the Interagency Council on Homelessness to Housing and our technical subcommittee. So the mission is to what is our mission? Is to lead Nevada's efforts to prevent and end homelessness, right? That's very basic, but that is the mission for the council. And our values are that every person matters and deserves to be treated with dignity and respect. Homelessness is unacceptable. Homelessness can be prevented. Homelessness is expensive and it's better to invest in solutions. Homelessness is solvable, and we've learned a lot about what works, and there is strength in collaboration. Next slide, please. We have 7 guiding principles that we use to lead our work. They are coordinating across partners, community, our community-led action. We have data-driven, actionable strategies and goals. We make commitments and we measure our results. We leverage existing and untapped resources. We remove all barriers that can possibly be removed, and we target priority populations. Next slide, please. Our strategic plan consists of 8 strategic issues. They are housing, homeless prevention and intervention, wraparound services, education and workforce development, coordination of primary and behavioral health, coordination of data and resources, policies, and long-term planning. And I'm going to very briefly explain what each of these entails, but for more detail, we're going to have to go to the actual strategic plan. But I want you to think as we go through the next 8 slides, and I go through the high level of what each of these entails, I want you to think about what we're talking about, what the strategies are, because the next item on our agenda really is to go into the work that we've been doing over the last year and a half or a year to develop out the action plan that goes with the strategic plan. So we're going to start really diving into what are the action steps that the work teams have come up with, and how do they apply, and are the action steps that and goals and strategies that are in the strategic issues in the right place, or do we need to shift some things around? So pay attention, wake up if you started getting sleepy, move around. I'm okay. You can stand up if you need to. You're on mute, so you can make some noise, but listen at the same time. So let's go to the next slide, Shelley. So strategic issue number 1, which is our housing goals. The housing goals strategic issue contains 6 key points, all of which support our statewide effort to preserve our current affordable housing stock and to increase the number of affordable units that are available across the state. This strategic plan addresses all of our stakeholders in the process, from property owners, federal, state, and local jurisdictions. I'd like to point out here that equitable access to housing by addressing discrimination on the basis of prior justice involvement, source of income, mental health status, or involvement in a housing program is critical to the success in getting every one of our fellow Nevadans housed. You'll also note that accountability is built into the plan in various ways, including the establishment of the infrastructure to develop a work group, an ongoing work group on supportive housing. Additionally, an important strategy being explored is to expand access to affordable housing is the innovative use of housing vouchers, such as replicating shared housing and other activities that were implemented during COVID. Next slide, please. Strategy 2 is homelessness prevention and intervention. This goal really is to divert people at risk of homelessness from needing more significant assistance. There are 4 key goals here in the strategic plan for prevention and intervention. We support local jurisdictions and agencies to optimize their funds and improve efficiencies. We want to work to break down the cycle from incarceration to homelessness and to increase public awareness of programs that are available. Next slide, please. Strategic issue number 3 really focuses on wraparound services. It's important. This goal is so important that we have, or this strategy is so important. We have 7 goals. We already use a housing first model where wraparound services looks at every client as a whole and full 360 perspective. The goal really here is to expand flexible funding to allow agencies the latitude to make the best decisions based on client needs and is not constricted by overly strict parameters on their funding. We want wraparound services to include increasing access to income resources, include the reenactment of SOAR programs that may have gone aside when we lost our statewide SOAR trainer. We want to ensure that we expand workforce development opportunities. And we also want to make it imperative that law enforcement programs are adapted and implemented that decriminalize homelessness, and that justice programs divert people experiencing homelessness from jail to appropriate housing supports and community resources. Next slide, please. Strategic issue number 4, education and workforce development. It really is to expand the education and workforce development opportunities with its 7 goals. This includes increasing funding for and access to education opportunities and workforce development programs that have a positive correlation on increasing wages and job opportunities. This also includes expanding access to life skills education that some people may be missing, advocating for equalizing the wage rate among all genders and races, providing support for reentry initiatives so that those that have paid their debt to society can begin to rebuild their lives with dignity. Next slide, please. Strategy 5, coordination of primary and behavioral health goals, really helps lead us with 3 goals. We'll strive for homeless service agencies to collaborate with clients' care providers to promote the best options available to the client. This includes working with acute care facilities, psychiatric facilities, and substance treatment facilities to coordinate a plan so a client doesn't leave to go to the streets. Our goal is to build on the work of the care facilities and move them into housing with supports if needed, so that the client has the best chance of success. Next slide, please. Strategic issue 6 focuses on coordination of data between all agencies in the state with 2 goals. Currently, every system of care in Nevada uses its own data information program, necessitating our clients having to retell their story every time they seek assistance from a different agency. We recognize that this is not a trauma-informed care approach to service delivery. Therefore, we strive to rectify this by finding a way to share data across all programs and all systems throughout the state of Nevada. UNLV is working as a collaborative partner to help us map our systems across the state so that we can see the data similarities and differences between the various systems of care, and allowing us to make informed decisions around data sharing. Next slide, please. Strategic issue 7 is advocating for policies on a local and state level to support the efforts for our continuum, our providers, and the people that they serve. This strategic issue has 4 goals. As mentioned earlier, this includes advocating for funding to preserve and expand low-income and affordable housing units. This also includes advocating for modified and expanded zoning and accommodate affordable housing and transit-oriented communities. We're also focusing on advocating for policies that support ending veteran homelessness, such as HUD-VASH programs, and to support racial and gender equity and justice. Next slide, please. The 8th and last issue in the strategic plan focuses on long-term planning with 6 goals. This includes an expanded educational outreach program to dispel myths around affordable housing and homelessness, to sustain and build on opportunities that arose during the pandemic, putting people with lived experience at the center of our conversations and plans in order to address the issues as they are, and not as we see them, to rehabilitate and expand naturally occurring low-income and affordable housing. And finally, we're looking at promoting a framework that is focused on justice, including racial, social, and economic. So that very high-level overview of the strategic issues, 8 strategic issues of the strategic plan. was very quick, I know. But I'm hoping that gives you a sense of kind of what's in the strategic plan, where we're going, so that as we continue to talk about the strategic plan and the issues, the strategic issues, you have a sense of what's in that plan and what action steps we need to move forward. So I'm hoping that the presentation that Shelley and I have given you has kind of grounded you and given you the framework that you all need to be active members of the Technical Assistance Committee and to help give you the foundation that you need for our conversations as we move forward. So at this point, I'm going to open it up for any questions from the team. Adrian.
Thank you for the presentation, Adrian Babbitt, for the record. We have to do that every time, the for the record thing. The presentation mentioned that there were regular updates on like what progress has already been completed since this group came into existence. Where are those documents found so that new members might see like what are the accomplishments, the overview accomplishments, like for every year, every couple of years? I forget the frequency of that.
Are you referring to the reports to the governor and the LCB?
Yes.
Okay. Shelley, can you point them to where they can find those reports?
I actually don't know the answer to that question. I'll have to find out and get back to you all.
I would think they should be posted on the website.
And the website you're referring to is that open meeting law website?
They should be, I would think they should be posted on the ICHH website. Yeah.
Yeah, that's what I'm wondering, and I'll find out. I'll reach out and see once we've submitted it to the governor and LCB, where does it get published? Because that piece I'm not sure of.
Thank you.
Other questions, comments, concerns? I see you're all still, well, some of you are still awake, so this is the good thing. Shelley, thank you for your presentation. I appreciate it. Okay, so if I'm not hearing any questions or concerns on this agenda item, I'm going to go ahead and close the agenda item. So I'll just pause for just a second to give you a second to interrupt me if there is a lingering question. Okay, seeing none, hearing none, I'm going to close this agenda item and we will move on to the next agenda item, which is agenda item number 6 for possible action, discussion, review, and possible reorganization of the strategic issues champions, including reassignment of existing strategic issue champions and assignment of 3 new subcommittee members. Okay. So that's a mouthful. Okay, let's see. Discussion, review, and possible reorganization of strategic issues champions. Okay, so let's talk about for our new members. Let me bring you up to speed. We have champions for each of the strategic issues. So we had taken each strategic issue that I very briefly went through and kind of broke them out to work teams and had champions from this team, from this Technical Assistance Committee, to champion each of those strategic issues, and then worked with the communities, worked with our COCs, the agencies, and the people that they serve to help develop action steps to go with that strategic issue so that we could bring that back and we could roll back up into a larger action plan to go with the strategic plan. Our goal was to have that strategic plan, the first draft of that strategic plan, done by the end of March so that we could then do some massaging and cleaning that up and have it done for have a tight I don't want to say draft, but a tight document by August for the ICHH, so that they can utilize it for their bill drafts as they're preparing for the next legislative session. We are a bit behind schedule because we've had some folks that have not been able to fully fulfill their roles as champions, and we've got some gaping holes in our action plan as it stands. So let's pull up our list of champions and kind of where we are. And I'm not sure if this is in the right place on the agenda, or if it should have been after we talked about where we are with the actual action plan. But I do know that in reviewing the action plan and where things have been submitted in the action plan, we have gaping holes in our action plan for particularly two areas: for homeless prevention and intervention, and for education and workforce development. Those two subgroups or strategic issue groups have not submitted anything for the action plan. And as you can see at this point, there's a couple of yellow spaces that highlight that there are vacancies in the teams, and one being a champion and two being co-chairs or co-champions in a couple of the strategic issues. And there might be some area where some folks are feeling there are some folks that are in multiple groups that might be interested in kind of moving around at this point, because my speculation is that as we look at what has been turned in thus far and start massaging, we may need to go back out to our groups and have more conversation or get more information. It may be a great opportunity for us to shift some things around, and maybe even have an opportunity to take for some folks that maybe are on more than one group, to lighten their load, or maybe to get some their feet wet in a different area, so that some folks can have some experience in a different area. I mean, we can do anything y'all want to do as far as this is concerned. So we're open for conversation, discussion, opportunities. Bring it on. Bring on your ideas and suggestions. Adrian.
Thanks, Michelle. So Adrian Babbitt, for the record, I participated on a couple of these working groups as before joining in this capacity. The chairs or the champion, obviously Scott Benton on homelessness prevention and intervention is no longer participating. The co-chairs, Karen Van Hest, and I'm not familiar with the second name, Pamela Juniel, who's also the champion of another working group. Is that individual still on or participating?
That is a great question. As you can see, Dr. Janelle is on, her name is on 3 different work teams. So as I indicated, I think some people might be overextended. I'm not sure to what extent Dr. Janelle has or has not been able to be involved in those work teams. As we know, homeless prevention and intervention and education and workforce development, neither one of those teams submitted anything for the action plan for the roll-up. Karen is on the call though. So Karen, I don't know if you can speak to any of that.
Yes, I was just going to. Karen Van Hest for the record. So for wraparound services, Nolga, Dr. Pamela and we met last week and spoke about Nolga wanted to get the websites of the COCs for the different areas, northern, south, and rural, so that she could put in, because Brooke had asked some questions on the documentation that Nolga had provided last month. Now, Dr. Pamela said that I know that she's really busy, but she was working on the education and the workforce development plan. But since nobody else is on there, she's kind of doing it all by herself as much as she possibly can. And nothing going on with the homelessness prevention and intervention. Hoping for a champion on that one. So that's my update on all of that.
Thank you, Karen. Adrian, did that answer your question?
Yes, I think so. I want to make sure that we're not reassigning work that might be happening, but we just haven't received an update. And because I don't know many of those that are on the call and or some of the names that are listed, I just want to make sure I have sort of a grounding on where we're at. I was at the conference where this was presented and everybody could put their emails in if they wanted to participate, but that was several months ago at this point, and I feel like perhaps the momentum has been lost on that. So just wondering what the engagement has been to try to pick that up.
So Karen Van Hest for the record. So I do know that both Dr. Pamela and Nolga had reached out to that email list that we had on one of the Excel spreadsheets for those that were interested in the strategic planning, different groups and everything. So we had reached out and emailed to those that were still interested from the conference. And there was several of them. So on the wraparound services, that's where Nolga, Dr. Pamela, and I had worked together on what we had heard back from those that were still interested and gave their opinions on everything. But for for the other strategic plans there, haven't heard anything. So it's kind of like in limbo right now.
Yeah. So Adrian, again, I'm happy to volunteer as my preference would be co-chair and not champion. Although I think that looking at the homeless prevention and intervention, there likely is some duplication from the other working groups that we might be able to sort of start some draft. So I think maybe looking at what's already been submitted to see what we might be able to frame for some of these gaps might be a good place to start.
I think that makes a lot of sense. Any other thoughts? Anybody else want to step up and to fill any gaps or step out or change or ask for a change? If anybody has a burning desire to take over long-term planning or data and resources, I'm glad to step aside. I don't have a, you know, my ego will not be hurt.
Michelle, did long-term planning submit their draft? Okay, I just want to make sure.
Yes, we did. And we actually have meetings on the calendar for the rest of the year. So,
okay.
Except that we did not meet this morning, but because we really didn't have anything to go over this morning. Come on, guys. Don't be shy. You got to unmute so we can hear you.
This is Julie King for the record, just wanting to participate a little more before making any kind of commitment like that. Like I don't know what these all do, and don't know what the commitment is. I feel like it's too new for me to be like, oh yeah, okay, I'll co-chair with you, or I'll do this or that. Let me just get a couple more meetings under my belt first before jumping in as a co-chair or chair or a champion or whatever.
Okay, so it sounds like we're not getting much for folks to step up.
I'll do the co-chair. I'll do the co-chair for the education and workforce development.
Oh, all right. Thank you, Kimberly.
Thank you.
Woohoo!
Michelle, this is Adrian. Perhaps it would be helpful to sort of define what a champion and co-chair's responsibilities would likely be so that we can make informed decisions.
Okay, great question. So we're kind of defining them as we go, to be honest with you. As everything with the technical assistance committee, as we developed it, the Technical Assistance Committee, because, you know, this is fairly new under the ICHH. But the champion and the co-chairs really have been calling the meetings of the community, right? They've been scheduling the meetings, facilitating the meetings of our community members. So making sure that we are including folks from all over the state that pertain to your strategic issue, and that we're getting the word out about your meetings that you're having regular meetings of those strategic, of those folks, and you're bringing them to the table to help identify whatever it is. Now, right now, we're working on the action plan, right? And developing the action steps for the action plan. We haven't decided next steps, what that's going to be, if there is a next step, or if they kind of go away after we develop the action plan. We haven't determined that yet. But right now, we're focused on the development of the action plan. But we needed to have somebody own each one of them. So that's the champion, and the co-chairs are kind of there to help support. You want co-champions? I don't care. You can call yourselves co-champions. You can call yourselves, you know, co-leaders. I don't care what term you use. Those are just the terms that we came up with. It's just many hands make light work, you know.
Thank you. I appreciate that. This is Adrienne. I want to participate. I want to play a role. I'm just nervous that I'm overcommitting myself to something that I don't really fully understand. And so if you want to put my name on every single yellow, like I will do my very best to contribute and to participate and fulfill that role. But it's, I'm nervous. I'm worried that, if I'm championing something that, then like, am I held responsible if it doesn't go well? I just, I have some anxiety around that. So if there's a collaboration, if there's somebody that will, co-champion, co-lead and has capacity to really collaborate and work on this, then let's do it. I'm just concerned. I think capacity is a big problem in our community, and people are burned out, and we have new membership to this group, which I think is going to be helpful. But I don't also want to burn out our new members, as with a lot of additional stuff. So those are my concerns and fears, if you will.
This is Karen Van Hest for the record. So I totally understand your fears there, but I know that when Nolga and Dr. Pamela and I have met, we do a lot of communicating and just start talking and just start writing things out, as we're talking and everything. And then it's just like everything just comes together. Shelly or Michelle, I don't know if we have what Noga has turned in from last month. So maybe if we could show that to Adrienne so she can see, and maybe that'll clarify some, take away some scaredness of everything. I mean, because personally, I think that helps me out. But I know that Noga had a question from Brooke from last month's meeting, because it looked like Noga had put everything all in there. So she was kind of concerned on that, going, I don't know what else she wants me to put on there. But all we could think of was maybe the COC's phone numbers, their, you know, their website and everything like that.
Shelley, do you have what Karen is referring to?
Yes, there it is.
Dun, da, da, da.
So that's the housing. That one's housing. There's the workforce. That's prevention and intervention. There's nothing under the potential action. There's wraparound services. That's the one you're referring to, Karen, right?
Correct. And I believe last month we didn't have any COCs that was in the meeting. Am I correct on that? So there was nobody that was able to respond.
Okay. I'm wondering if, so we have somebody, you know, Shannon is not necessarily a technical assistance committee member, but she is a co-chair with Brooke on one of our groups on the policy group, I think, or the housing group, one of the two. I'm wondering if Shannon could give kind of her input on what it's been like and what her feedback has been. Shannon, I hate to put you on the spot, but you know, I am like
That's all right. This is Shannon Cow for the record. It was actually really fun process. I jumped in as chair because there was none available at the time. So I am actually one of the community members that were just signed up during that conference like you were talking about. What we basically did is went through each goal and did a analysis of it as the members of the policy group, and went through, you know, what's happening now, what we would like to see, barriers to that, and that kind of helped us develop those action plans for each one of the goals. So it was actually fairly simple. We were able to do all the work during the groups or during the meetings, which we had like every other week for an hour. So I think we met, I want to say like 5 or 6 times, and was able to develop pretty much the whole thing. I know Brooke obviously did some work behind the scenes to make it pretty and functional for what was needed, but it wasn't, I didn't feel like it was a whole lot of extra work. It was actually fun to have those conversations with different community members and having different perspectives and coming up with different ideas. So I don't know if that kind of helps, but it was, I feel like, not too horrible of a process, not too time consuming. As I said, Brooke probably did a lot of work behind the scenes to organize it and make it functional, but yeah, I don't feel like it was too much.
Thank you, Shannon. I don't know if is there anybody else who's a champion or co-chair that wants to speak up on their experience?
Michelle, this is Adrienne. I'd be interested to hear from you and what your capacity or time commitment was like, since you're championing 2 of the groups that have submitted for the draft.
Well, I don't know if that's fair. Um, I I have a monthly hour meeting for each of those. Let me see, is it hour meeting, hour and a half meeting? Let me check. Hour meeting for each of those work groups, and then about for those work groups probably an hour pre and post work each month. Now I have other work when you look at my calendar that's ICH related because of being the chair of this work group, but when I break it out, you know, that's probably a couple of hours a month is what I put into that. But again, most of the work was done right during the meetings. I actually pulled up the agenda and was literally typing in the information while we were having the meetings, and was completing the information during the meetings. And you can even see the information I even sent to the homelessness to housing team was in different colors because I color coded what information came out of which meetings and stuff, for just because I am like that. But yeah, so also my co-chair, or I didn't have a co-chair for long-term planning, so I just reached out to somebody else who was, well, Austin, who was in that group, and he co-chaired a meeting for me because I needed somebody to co-chair or chair a meeting that I wasn't able to make. And we didn't want to lose momentum because we were having regular meetings. We had standard meetings monthly on the agenda or on the calendar. We had really good momentum happening. We had good conversations happening, and I didn't want to lose that. And so we just stepped in, took notes, sent them to me. I incorporated them into the running document I already had, and we just kept it rolling. And, you know, more folks have been joining each month, and we just kept it going. So I feel it's been good, and folks have been excited about being involved and having being involved with the community, being a part of the development. And I think that has, you know, helped tremendously, because it hasn't been a matter of having to, you know, beg and borrow for assistance. People are coming forward with their ideas and suggestions. So people want to help. People want their voices heard, and they want to be involved in what we're doing at the state level. We just need to give them the platform to be involved. And I know that, you know, I've gotten emails from folks saying, you know, I signed up to be part of X work group, and I haven't gotten any information on it. So what's happening with this?
Okay, so Adrienne, for the record, I will take on the champion role for homelessness prevention and intervention. My preference would be to have some really good support as a co-champion or co-chairs. Karen, I don't know if, maybe we can talk offline about the conversations or momentum that you and Dr. Pam have had after Scott didn't convene anybody, what's happening, or potentially if you both feel you need to take a step back and we need to have different co-chairs. I need to talk to people in order to process verbally. And so I just want to make sure that whoever the co-chairs are have capacity to listen to me talk. Talk back.
This is Karen Van Hess for the record. So Adrienne, that's perfect. We actually never met. Scott took on that champion and then that was it. No meetings, no nothing, never heard anything, reached out to him and everything. So this never got started. I'm sorry. But yeah, that has never, strategic plan has never got started. So I've done, like I said, the wraparound services and just been waiting for the homelessness prevention and intervention one.
Karen, so I take it to mean that you're still able and willing to participate as co-chair.
Yes, ma'am.
Thank you, Adrienne.
Michelle, this is Adrienne. Do you need a co-chair, or since you've already submitted, is that something that you're still that we're not able to close this action item until we get all of these things filled in?
Oh, it's not critical that I have a co-chair, but it would be nice to have one, but I don't have to have one. I got big shoulders. But I won't turn it down if anybody wants to volunteer. Any more discussion on this item? Christy.
Hi, Christy Costa for the record. I'm with Adrienne on this. I'm a little bit apprehensive, not sure what I'm volunteering for, not sure what I can bring to the table. But I am a licensed social worker. I'm going on 8 years working with Northern Nevada Community Housing. Do a little bit of everything, wear all sorts of different hats. I am open to having some discussions on how I could fill in and help, but I don't really know, like I said, what I'm volunteering for or what's expected of that. But I am definitely willing to help and see where I can fill in. I just don't want to volunteer for something I'm not adequately prepared for, if you will.
Okay. I appreciate that. And why don't we do this? You can always volunteer. This is not the last time you can volunteer. So we put this item on the agenda to volunteer because we had some spaces that needed to get filled.
Right.
But we know that, as I said earlier, more hands make light work. And if there are spaces where any of you want to get involved and you know, help with the leadership role in any of these work teams, then by all means, step up. Let us know that that's what you want. That's a team you would like to be, you know, a co-chair with, and we can definitely get you connected. So if any of you determine, especially after our next agenda item, or we may have to wait till next month, depending on what Shelley tells me in a minute. But if you determine later that you want to step up, just let us know, and we won't turn you down. So let's just put it that way. So this is not the last time you have an opportunity to step into that role, because you may say, once we start going through some of the things that have been turned in, and that, you know, we're going to continue to work on in an area, you might go, oh, I can fit in right there, and I think I could help lead that discussion really well and help, you know, lead that work really well. Sign me up. And, you know, so I encourage you to do that. Okay? We all at least do a thumbs up on that. All right. So with that, I don't know that we really need to take action on any of these items. Am I accurate there, Shelley? Can I get a?
Yeah, Chair, I don't think we need any action on it. Well, we might, because Adrian volunteering for the homelessness prevention. Does that need to be something that you act on? Or are we okay just to update live and move forward?
I don't think we have to, but.
Because for your initial volunteering of the strategic issues, you didn't do any voting on that, right?
I don't think we did.
Okay, then I don't think we need to do anything fancy for this one.
Okay, thank you. So with that, I think at this point we'll close that item. I know that the meeting itself is scheduled for till 3:30. Do we go until the meeting is just over, or do we try to end by 3:30?
That is something I am not sure of, and I don't see Ryan is present right now to be able to clarify either. But in being completely honest, I'm not sure if we can even discuss number 7, action item 7, or agenda item 7 anyways.
Do we not have quorum?
Well, we have quorum, but we don't have individuals to speak on each of the issues to give us an update.
Well, this is actually to speak on the update of the action plan.
Oh, yes, you're right.
So, okay, so okay, I know what we'll do. Okay, so let's move to agenda item number 7 for possible action. This is Champions Report status update for our COC and TA subcommittee members regarding the progress and development, content, and language to be included in their assigned sections of the Nevada Strategic Plan on Homelessness. Updates will be populated during the meeting. Okay, so Shelley has, and I don't know, was this included in our appointment? Did everybody get a copy of the spreadsheet? Shelley?
We emailed it, and I may need Abigail or Isabel to clarify for me. We emailed it out to everyone from the homeless to housing email address.
Okay, so everybody, all the technical assistance committee members should have a copy of the spreadsheet that you were showing just a little bit ago.
I believe so, yes. It would have been sent about maybe a week or 2 ago.
Did everybody get a copy of that?
It was sent out on May 3rd.
Thank you, Karen.
And it was from the homeless to housing email?
Correct.
Thank you, Karen. Okay, we have, I know it's getting close to 3:30. I'd like to do a temperature check on our members because I know that this meeting is scheduled until 3:30. Do folks need to leave by 3:30?
I have to go to work.
You have to go to work. Okay.
This is Austin Pollard for the record. I do have a 3:30 meeting that I have to jump on.
Okay.
And
I'm
this is-
available beyond the 3:30 time if needed.
This is Karen Van Hest, and I have a meeting that I need to jump onto at 3:30.
Okay. Okay. So in the interest of time, here's what I would like to suggest. I will leave it up to you all to tell me whether you agree with this plan or not. What I would like to suggest is that we have a little bit of homework. And that we have the work, you have the worksheet that, and if we need to resend it, we can resend it. You have the worksheet in front of you. We went over the strategic plan, the strategic issues, and the high-level strategic plan. We can make sure that you have a copy of the actual strategic plan itself. So we can make sure that you have that, a copy of that. And if we can, but the goals are specific, are written out in this worksheet. And if we could each take a look at what has been submitted for each strategic issue, each goal, and the potential plans of action. And think about, each of those actions and the goal, do they belong there in that section? For example, under strategic issue 1, housing, goal 1, preserve the existing affordable low-income housing stock. And then there's a list of actions. Create a preservation fund with the best practice for a private-public partnership for preservation. Does that belong there? Does it belong in policy? Does it belong in long-term planning? Where does that fit best? Right? Same thing. Establish consistent data tracking systems of units that need to be preserved and how long the affordable housing development's affordability period lasts. Does that belong in housing? Does that belong in data and resources? So let's think that through. Let's think through each one of the action steps through this worksheet between now and next month. And think through, where do you think each action step really belongs? Because one of the things we've been talking about each month when we meet over since the beginning of the year, is that there might be action steps that when we bring this all together and do the roll up, that don't really belong in our strategic issue area, but might belong in somebody else's strategic issue area. So what do you all think about doing that and having that as a homework assignment to bring back at our next meeting?
Michelle, this is Adrian. Is it possible to divide and conquer so that we can, instead of everybody looking at all of the submitted drafts, all of us look at 1 or 2, and that way we can really focus our energies on doing a good job? Or there's a lot on here, and I just want to make sure that we're if it makes sense for everybody to look at all of it, then that's fine. If we feel like we can say, you know, Adrian, look at strategic issue 1 and 2, and Julie, look at strategic issue 3 and 4, or whatever. Maybe that would be a better use of a team effort.
I'm open to whatever y'all want to do. So thoughts? And if you want to do that, how do you want to divide it up? We've got two strategic issues that did not get turned in. So we really only have 6 strategic issues. You have to unmute yourself.
Yeah, okay. I guess this is Adrian. In the interest of time and just making a decision, I guess we'll all just look at all of them.
Do the best that you can between now and next month, and then we'll go through them during the meeting. That'll be the bulk of our meeting next month. Okay? I think I'm losing everybody because nobody is responding to me.
I'm giving you a thumbs up.
You got it.
I
Yes.
appreciate that, Julie, because I feel like I'm talking to a wall right now. All right. So we've all got our assignments. We're going to do the best we can to get through these and come back with suggestions and ideas for next month. And then we will go through, we'll bring back our ideas to our next meeting. Shelley, our next meeting, that's really what we're going to focus on. Okay. And I'll help you with the wording on what that looks like on the agenda. So with that, anything else on this agenda item? Karen.
I need to go. Sorry.
Okay. Okay.
Have a good afternoon.
Okay. Kimberly, did you have something?
No, I got to bounce too.
Okay.
Bye, y'all.
Bye. So with that, I'm going to close agenda item number 7. Number 8, for information only, discussion of agenda items for the next meeting. Anything critical that needs to be on the next agenda item, next agenda?
Well, I think our discussion about the, our review of the action plan and all that.
Yeah. Anything other than that? If something comes up in the next week and a half, let us know. Otherwise, we will go ahead and that will be our main focus for our next meeting. With that, we will go ahead and close this agenda item. We will go to agenda item 9, general public comment. This is the last public comment for the meeting. No action may be taken upon a matter raised under this item of the agenda until the matter itself has been specifically included on an agenda as an item upon which action may be taken. Comments will be limited to 3 minutes. If you are making public comment via phone, please call 1-775-321-6111, ID 758-695, 708#. Please unmute yourself and state your name for the record if you are making public comment. Any public comment? Seeing none, hearing none, I'm going to go ahead and close this public comment. At this time, it is 3:36 p.m. on 5/21/2024, and I am going to adjourn this meeting of the Interagency Council on Homelessness to Housing Technical Assistance Committee. We will see you all the same back time, same back channel next month for our meeting. Thank you all for being here and for your participation.
Bye, everybody.
Thank you.